Okay, well, we can jump in and get started. Um, I'm Matt Kruger Andes, and Alexa Voss is joining me here. And thank you for joining us tonight as we present on the North Carolina Family Law 101 presentation. Tonight, we're going to be, looking at the sort of the uh, five topics that sort of comprise the family law here in North Carolina: custody, child support, equitable distribution, spousal support, and divorce. Alexa and I will discuss, each one of these topics real briefly, just kind of give a general overview, and then take any questions that we have as we go through. Um, and sort of march through that way. Let's start with custody.
All right, so good evening to our attendees. I believe there are two of you on the line, and Matt and I will do our best to explain these areas of the law in kind of a big picture overview, so that you can leave here knowing a little bit more about each individual area than you did before we started. So, to start off, one of the most, I would say, prevalent family law claims that we deal with and most folks deal with is child custody. So in North Carolina, typically there are um, two big concerns when we're dealing with custody. As you can see, as the fourth line down on this slideshow, we're really concerned about physical custody, which is time sharing. Where is that child going to spend the night? Who are they going to be with for Christmas? Things like that. Where are exchanges going to take place? And the second kind of big part of custody is legal custody. So that is decision making. So when you're talking about legal custody, you'll hear lots of terms tossed around: sole legal custody, primary legal custody, all of those types of things. But in effect, what you're really looking at is who is in charge of making decisions for the child. Who's going to decide whether the child needs braces or is going to go to this public school versus that private school. So those two pots combined are what every judge is going to look to decide in terms of a custody order. So in kind of talking in broad strokes, biological parents have the most rights when it comes to children, but in the state of North Carolina, any legal adult can file for custody, biological parent or not. It is a different standard for non-biological parents to file for custody, and biological parents are granted significant rights under the Constitution to be involved with their children's lives. But that does not necessarily mean that you have to be a biological parent to file. So, in talking about an initial determination of custody, an action for custody can be filed anytime after the child is born through the day before they turn 18 or graduate from high school, whichever occurs later in most cases. So a lot of times a custody filing will occur at some point between that. One important thing to know is that custody is always modifiable. So let's say you were in a custody lawsuit with another party, and a child custody order was entered when the child was 3. That order can easily be modified until that child turns 18 any number of times. The burden for modification is typically that you have to show that a substantial change in circumstances has occurred since the entry of the initial order prior to the subsequent order. Sometimes people have an easy time showing that burden, and other times it's a little more difficult. I will say most times judges are hesitant to modify custody orders at the drop of a hat because they want to make sure that there is some consistency for the children at issue. So, speaking of the children at issue, it's important to know what a judge will look at in terms of what is the standard that guides them in terms of making a decision. And what they call the polar star of their decision is the best interests of the children. So, what that means is instead of if you have a case between mom and dad, the judge isn't necessarily going to make a decision that is what's best for mom or what's best for dad, but the goal is to make a custody determination that is in the best interests of the child. So sometimes that means that the party who's seeking custody does not always get what he or she desires because the judge decides that a different standard or a different schedule or a different arrangement would be in the best interest of the child. But with that in mind, that is always going to be the judge's guiding star. I think it's important to note that in North Carolina, there is no real precedent to say that a child gets to choose whom they get to live with. I think that's a pretty common misconception that we deal with. In my office, we have a common saying that a child has a voice but not a vote. So when it comes time to talk about, the child's wishes, that varies from case to case as to how involved that child is. And if you are proceeding pro se or if you have an attorney, the advice that you will get will vary widely when it comes to that. Um, so again, this slide talks about modification. It's always modifiable. And I think it's just important to know that the goal is that these orders will continue to be followed until they no longer benefit the child. Um, Anyone have any questions so far on custody?
I have a question. Is there any
Matt has a
preference?
question. Yes, Matt.
Is there any preference given to the mother versus a father, say in family court?
Great question, Matt. There is no maternal or paternal presumption in North Carolina. That was in previous decades in North Carolina and in most states there was a maternal presumption that has been abolished. So no parent has a starting footstep over the other. And I will say there is a lot of discussion about is there a default to joint custody or anything like that. I will say it is very, very, very judge specific in Mecklenburg as to what the judge personally will start out with, knowing no facts. And what the facts will tell them in terms of should it be a joint and equal schedule, should one parent have more time, and so on and so forth. So as you can see at the bottom of the slide, we've included a few of the most common schedules. Matt can tell you, custody schedules are probably infinite. They are designed to fit the parties and the child. Every child is different, every party is different, and a schedule that works for one may not work for another. But these are some of the most common ones we see. Typically, in every other weekend schedule, that means that one parent's going to have the child the majority of the time, and one parent's going to have them every other weekend. A 225 or a 223 is designed to give each party somewhat equivalent weekday versus weekend time. So, for example, in a 225, you're looking at, let's say, mom has every Monday and Tuesday, dad has every Wednesday and Thursday, and they'll alternate the 3 days of the weekend. So, that's a pretty popular one, I would say. Week on, week off, hugely popular, especially for older kids who are able to stay longer with each parent. I will say that the more frequent exchanges are typically talked about as being beneficial for younger children because it's beneficial for them to have more exposure to each parent when they're younger to build those bonds. The 9-5 or the 8-6, those are for parents who are okay spending even longer blocks of time with the child. And it really is decided by the user and the child at issue. So I think those are the main points about custody that I can think of at the moment. Obviously, there are about 100 other things we can tell you about custody depending on the case. But does anyone have any specific questions or queries about custody that they have a question about or want to ask Matt or I?
I think one important thing to note that Alexa kind of touched on is that the custody schedules, it can be any variation on, any number of days of the week. A court could order any number of days, or the parties could, as part of a sort of a settlement agreement, agree to any type of schedule, which I think brings up another point that the court ordered schedule is there almost as like a default or a backdrop if the parties can't agree among themselves on the custody arrangement. So even if the parties have, week on, week off custody schedule, it's not set in stone that, the parties can still agree among themselves to, it's the child's birthday. And so, the parents want to, share time on that day. The parties can vary that schedule by agreement. So I think it's just important to note that the court orders enforceable as a court order, but the parents can always get along and sort of agree to slight variations if that's what they're most comfortable with.
Absolutely. And Matt's comment brings up two other very important points. One common question that we get is how are these orders enforced if a party is violating them? And this will be an enforcement remedy that you'll hear Matt and I reference probably a decent amount during this presentation. But if you go to court for child custody and an order is entered, you theoretically have a remedy called contempt of court. There are two kinds of contempt. There's what we call civil contempt and criminal contempt. Both are different. They have different triggers and things like that. But effectively, what you are saying and what you're petitioning the court to say is that the other party has willfully violated the court order with a disregard for what the judge has thought was in the best interest of the child. There are pretty significant I would say repercussions for if the judge finds you in contempt. They can include fines, they can include censure, they can even include jail time. So it's very important that you're aware of the seriousness of following these orders. As much as we wish people would work together, please do know that a court order can and will be enforced, especially in Mecklenburg County and in any county in the state. That also leads me to tell you a little bit about the procedure. In Mecklenburg County, if you're filing here, if you file a complaint for custody, you are mandated to attend custody mediation with the other party before the judge will enter an order. That is a policy of the county, it's a policy of the state, really, to try to get folks to work out these deals before they have to go in front of a judge. Custody mediation, if you agree, that's great. The mediator will help you draw up something, but if not, it is a necessary step that you need to complete along the way, unless the judge finds that there's very good cause to waive that mediation requirement. Any other questions or comments about anything custody related so far?
Talk for just a minute about what would be an example of substantial change of circumstances that would support a modification. I think one that I see a lot is maybe one of the parents moves either farther away from the other one, in which case it's tough to manage the exchanges on a 2-2-5 schedule, or one of the parents was living farther away, now moves closer, and all of a sudden has the ability to spend more time with their child, and then wants to modify to get closer to a 50-50 schedule. That's sort of the one I see come up pretty often.
Yeah, and I also think it's important. The passage of time is a big change in circumstances. If you enter an order when a child is 4 or 5 and that child is now in high school, obviously what was in their interest as a 4 or 5-year-old is going to be significantly different than it is when they are an older teenager. I will say that custody, in terms of all the claims we're going to talk about tonight, it is one that has the ability to look at a very wide scope of factors, including parental behavior. So if a parent is engaging in illicit drug use or alcoholism, or engages in any of those behaviors that could impair their ability to provide adequate care for a child, that is also something the court can consider in terms of modifying an order. All right, I think that's all we have for custody right now, if no one has any questions. So I think we're ready to go ahead and move on, and I'll let Matt take the wheel as it relates to child support.
Sure. And this is a good, child support is an interesting topic to look at, sort of in contrast to child custody, because as Alexa mentioned, the range of factors you can look at when determining a custody schedule. Child support, by contrast, is fairly almost cut and dry or formulaic, in that the amount of child support that is payable is typically based on a few numbers that are plugged into a worksheet, and then that will spit out what the monthly support obligation is. And so backing up first, what is child support? Sort of in my own words, child support is, financial support that one parent of a minor child pays to the other parent of the minor child where the parents aren't living together. And it doesn't matter if the parties were ever married. And the child support obligation lasts until the child turns 18 or graduates high school, whichever is later. There are some exceptions. If the child is, disabled with special needs, then in North Carolina, the child support can run till the age of 20. And also, in addition to just monetary support, child support can mean things like covering the child on health insurance, like medical, dental, vision, paying for the child's daycare or childcare costs, and paying also the uninsured medical expenses of the child. Child support doesn't cover the costs of certain extracurricular activities like sports or dance or music classes. Those are things that the parties can agree on allocating those costs, but typically a court won't order them as part of child support. It's not part of sort of the general formula that's used in North Carolina. And so, how is child support calculated? Well, it's calculated based on the monthly gross income of the parties, and it's also based on the physical custody arrangement that the parties have with respect to the child or their children, and of course, how many kids are involved too. And so, the first thing to look at in calculating the child support is which worksheet you need to use. And you can see that in the slide there that there's worksheet A, there's worksheet B, and there's worksheet C. And so you need to know which worksheet to use to plug in the relevant numbers to come up with that child support number. And I should say that these are all under the child support guidelines. There are cases where you might go off guidelines, where we can talk about in a minute, or you might also deviate from the guidelines. But most cases fall under the child support guidelines, where you have to look at, what's the custody arrangement. If it's closer to a shared or 50-50 custody, you're going to be on worksheet A. I'm sorry, worksheet B. If there's one parent that has, it sort of works out to at least 2/3 physical custody, meaning of the 365 overnights in a year, they have about 2/3 of those overnights. Then you're on worksheet A. And if the parties are closer to 50-50, or stated another way, if each parent has at least 123 overnights with the child, then you're on worksheet B. And so once you figure out based on the number of overnights, are you on worksheet A or B? If you're on worksheet A, then you've got some inputs into the worksheet. You've got monthly gross income that you look at of each parent. You look at daycare costs that are paid by each parent. You look at who's covering the insurance cost, carrying the child on their insurance. And then you can look at things like extraordinary expenses. And those are a little bit unusual, but things like if you have a special needs child, maybe you need a special school to send the child to, and so the cost of that. And then also if child support's being paid for any other children too. So you plug the numbers right into the worksheet, and it's a calculator, and that will sort of spit out a number, and that will be the monthly child support obligation. And if you're on worksheet A, it doesn't really matter if what I'll call the non-custodial parent, or the parent with less custodial time with the child. It doesn't matter if you've got 1 overnight or 100, the child support figure will be the same. If you're on worksheet B, where again, you're closer to the 50-50 arrangement, then the number of nights will impact the amount of support that is generated through that worksheet. There's also a worksheet C. That's where you've got more than one child and the parents are splitting the time differently with the two children, and it's not very commonly used. I don't know if Alexa, if you've ever seen that used, but the vast majority of situations are going to be worksheet A or B. And then you've got, I mentioned earlier, the deviation. Those are situations where, that the worksheet and the formula will split out a number, but maybe it's way too low or way too high, based on the circumstances. For example, if, again, if you've got like a special needs child who has higher medical and other expenses, then maybe the worksheet number is not going to be sufficient to cover the needs of that child. And then there are cases also where you can be what they call off guidelines, and that will typically apply if the combined income of the parents is at least 480,000. I believe that number is adjusted every so often, but currently it's 480,000 at the combined annual income of the two parents. And if that's the situation, then you're not using the worksheets, you're not using the formula. Then you're looking at what are the reasonable needs of the child. Each party submits their own financial affidavit. And you're really looking at, okay, if the parties are, making millions and millions of dollars, the number that the calculator or the worksheet would spit out would be, maybe unnecessarily high, in which case you're off guidelines, and you can maybe determine what a lower amount might be, just looking at what the monthly needs and costs would be of that particular child or children. So that's how child support is calculated. And then, once that, the court enters its order on child support, it's typically has to stay in effect if you're looking at how is child support modified. And typically you need to show it not just a substantial change in circumstances, as you would with custody, but typically it's got to be at least 3 years, and you have to show that the support amount would be changed by at least 15%. So you can't just, file a motion to modify each year. Usually it's got to be 3 years go by. There are some exceptions. For example, if you've lost your job, for example, then you could file a motion to modify based on the involuntary loss of employment. I see that we've got the child support calculator in the chat, our webinar chat here. We've got a link to the child support calculator, so you can follow that link there to get a feel for what that looks like and the inputs that go into. Looks like that's the worksheet A, where you've got one parent with primary physical custody. So typically child support can change with a motion to modify after an order has been in place, usually for at least 3 years, and you've got a change in income, either much higher or lower, that would change the support amount by at least 15%.
Matt, it looks like we have a question from Shayna Bennett about child support when a child goes to college. Do you want to address that?
Yeah, so usually, a child support order in North Carolina will cover a minor child until the age of 18, or the child graduates from high school. So typically it wouldn't extend into college. There definitely are times when the parties can agree to that, to child support extending past high school and into college, if they wish to do that. But a court typically is not going to order beyond high school or the age of 18, whichever is later, unless it's part of an agreement that the parties have reached as part of a bigger sort of settlement agreement. Yeah. Any other questions?
I don't see any questions right now, Matt, but if it's all right, I might also talk a little bit about the Child Support Enforcement Agency for those who are listening. So this this is a little bit unique to child support when it comes to the family law claims in North Carolina, in that the state of North Carolina has a child support enforcement agency. It's statewide. Folks who are seeking child support for their child, but don't necessarily want to do it on their own or hire an attorney to do it may seek aid from the Child Support Enforcement Agency to file on their behalf. I will say this is a very, very, very popular thing to do. They have hundreds of cases, thousands of cases, and they do very good work at what they do in order to get money for children, and follow up on that and keep enforcement sharp on that. No one is required to use them, but it is a very good option for those who need assistance, at a free cost. So I think that's a good thing to know. There is a very strong child support enforcement contingent in Mecklenburg County. Typically, they're handling cases in courtroom 8110 every day, but they will help parents seek child support and get all the paperwork filed on their behalf. So I think that's just a neat resource that a lot of folks can use.
And speaking of enforcement, you reminded me, thank you, Alexa, that just like a custody order, a child support order is also enforceable by contempt powers of the court. So it's not just, any typical debt if you don't pay. It's enforceable with contempt powers, which can mean going to jail if you don't pay child support.
Absolutely. And I think to add on to what Matt was talking about in terms of enforcement, and no matter who is prosecuting the child support action, it is very important for a payee or a payor to realize that, again, this is gross income that's considered, and it's gross income from all sources. And a lot of folks uh, take issue with that because obviously a lot of the time it's not the amount of money that's going into their pocket at the end of the day. It's not the net check that you receive from your employer or anything like that. It is the gross amount of income that is received. So I think that's an important distinction to make. I also think it is important to note that if you have any kind of voluntary support agreement with the other payor and it needs to go back to court, child support is again a claim that can be modified, and revisited until that child turns 18 or graduates from high school, just like custody. So when we get into some of these other claims, you're going to hear us say that they're non-modifiable once they're entered, but these two child-related claims are modifiable so long as the child was still a minor.
And one other enforcement related point to note is that child support, I don't want to say, I'm not sure if I want to say typically, but often is collected through wage withholding. So the payor of child support isn't necessarily writing a check to the other side for the support each month. That payment is actually coming directly out of his paycheck, his or her paycheck, never actually sees it, and that money is collected and then provided to the payee parent. And that's typically part of the child support order in the case, requiring the wage withholding.
Matt, I think that's all I had on child support. Is there anything else that you want to address or any questions from the attendees that we can help answer right now about child support? Looks like we're free and clear. So our next topic is equitable distribution, which Matt will take you through.
Sure. So equitable distribution, which is not easy to say, is really sort of big picture. The parties are getting divorced and they're dividing up everything that they have. And how do they do it? How do you do it? How do you divide up what is, called the marital estate? And the way we do it in North Carolina is you first identify all the property, all the assets, all the debts that the parties have, and you look and see what is marital property, what is separate property, and what is divisible property. Because if you've got separate property, which typically is property or debt that existed with one party before the marriage or after the date of separation, then that's not really part of the marital estate. The marital estate is all of the assets and debts that were acquired by either party during the marriage. So starting the date they were married until the date of separation. Doesn't matter who is earning the money. Doesn't matter who is doing the work for the money. It's all part of a marriage is viewed as sort of an economic partnership in this sense. And so all that money, all that property, and all the debt is put into one big pot that is the marital estate. And so you've got that marital property, and then you've also got what's known as divisible property, which is also part of the marital estate. And that's typically, I think the easiest example to see would be if you've got property that, say, stock or investments that was marital, was acquired during the marriage, and then say one party has a retirement account, and then the parties separate, and that the investments in the retirement account keep appreciating. Well, that sort of passive appreciation on the property would be marital, and so it's still divisible between the two parties as part of the marital estate. I should make the distinction that if there are contributions in the retirement account after separation, that is separate. But sort of passive gains on an investment during the marriage, even if one party sort of has that investment under their control after separation, the passive gains or appreciation are going to be marital. And so they're going to be part of the big pot that is the marital estate. And so essentially, once you've identified and classified all the property, if you're looking at really the marital property and the divisible property, then the question is how you, first you have to value the property. And so if the parties own things like, real estate or things that need to be valued, you need to determine what the total value of the marital estate is, so that when it comes to distributing the property, you can look to see that each party is getting something close to near 50-50. You can see the note below there that North Carolina's equitable distribution is not equal distribution. So it's not necessarily going to be a 50-50 division of marital property, but you do need to know the total value of the estate, so that when a court or the parties agree on what the distribution is going to be, say it's a 51-49 distribution, you know what the value is and how you're going to divide up that value among the two parties. And typically what that looks like is you can actually just you identify all the property, and you can sort of put it all out into a chart where, okay, here's, say the estate's worth $200,000. Well, then you have in one column, you can have $100,000 worth of the property going to, husband, and the other 100,000 going to wife. And you've got to figure out how to divide up the property to get that division. And then coming back to, as I said, this is equitable distribution, not equal distribution. And so what that sort of brings into play in North Carolina is, and this is a sort of a statutory regime, but there are different factors that courts will look at, to determine what that distribution is going to be, whether it's going to be 50-50, whether it's going to be 52-48. I think maybe as far, 54 or 55, 45 might be as sort of extreme as you see in North Carolina. But that division is going to be based on a number of different factors that are all laid out in the statutes in North Carolina. And they include things like, how much separate property does one spouse have? What are the spouse's earning power? For example, if one spouse raised the party's kids while the other party worked and built a career, then the working party who built a career is going to have a higher earning potential coming out of the marriage. And so the other party may have a higher, more than 50% on the equitable distribution, just to compensate for his or her role during the marriage, and the fact that he or she will have less earning power coming out of it. I think those are sort of the high level bullet points. Alexa, do you have anything to add?
I think you covered it really well. I think one hugely important thing that we'll talk about when we get to divorce, but it's worth flagging here. Equitable distribution is one of the claims that, if it is not at least asserted by the time the parties are eligible to get divorced, it will be waived permanently. So what that means is that in North Carolina, and we'll get to this in a future slide, I promise. In North Carolina, you have a year and a day that you have to stay separated before you can get divorced. And if that time passes and you are eligible to get divorced and a judgment of divorce is entered and equitable distribution was not resolved via contract or asserted in a claim, you are waiving your right thereafter to have a judge help you divide your property. So it's hugely important for lawyers like Matt and I. That is actually one of the bar's mandates. It is not practice if we let folks get divorced without resolving that claim knowingly. So I think that's huge to discuss. And I think really the only other big thing to kind of talk about is what happens when the marital estate doesn't exist in perfect liquid, non-liquid items. So for instance, let's say the marital estate is made up the majority by a house, right? And y'all have some checking accounts, some savings accounts, but in order to truly split the marital estate half and half, you can't divide the house physically in half, or we wouldn't want to. But effectively, one person is getting more value than the other. A lot of times, the way that we remedy that by making the parties equal is by having the person who's getting the non-liquid asset pay what we call a distributive award, which is effectively just cash in order to make the other person even who's not getting the non-liquid asset. So I think that's just something to consider. It doesn't happen in every case. It's not required to happen, but it is very common. And I do see a question from Shayna Bennett. It says, so if a house was purchased before marriage, the other spouse does not have an advantage to the property. Matt, do you want to address a house purchased before the marriage?
Sure, absolutely. So it really all, it depends, because if one spouse purchased the house before the marriage, then it was their separate property coming into the marriage. But then oftentimes, that spouse who had it as their separate property might, for one reason or another, put their spouse on the deed to that house. Maybe they refinance the mortgage on that house and put that spouse on the deed. But if they do that, for example, then that is usually considered a gift to the marriage, and then that house is part of the marital estate. So you can do things, you can have the house as a separate property coming into the marriage, but unless you keep that separate, if you do keep that separate, then that is separate property. And it won't be part of the marital estate that's divided up as part of the divorce. But again, if you, for whatever reason, whether it's a refinance or otherwise sort of make that house a gift to the marriage, and you put your spouse in the deed, then yes, it's part of the marital estate. Both parties then have an equal claim to it. And then sort of, as Alexa said, it'll have to be, typically either one party will buy out the other party's interest in the house, or in some cases, the house will be sold, so that there's the liquidity to sort of divide up between the two parties.
Absolutely. I think that was a great answer, Matt. I think one of the things that's not huge to note, but we do find it as a question fairly often is whether or not marital fault is considered in the property distribution if one party had an affair or anything like that. Marital fault is typically not a consideration in the equitable distribution proceeding. The only thing the judge will consider is what we would call economic fault, which means reckless disposal of assets, hiding assets, things like that that are truly financial in nature. But when we talk about spousal support, which I believe is next, we'll get a little bit more into what a consideration of marital misconduct would be.
Yeah, so to that point, right, marital misconduct, even though isn't a per se factor in equitable distribution, there is something called marital waste, which is taken into account, and that would be, if there was, say, an affair and $50,000 is spent on the mistress, then that $50,000 is marital waste, and that is counted against sort of that party when it comes to dividing up the marital estate.
Does anyone have any questions about equitable distribution? I think Matt and I can agree that if we could talk about one claim for at least 3 hours, it might be equitable distribution.
And
But we're
I would
happy
make
to
one
answer.
last, sure, sorry.
Yeah, go ahead.
It was malpractice for me not to mention that you must raise that and assert the equitable distribution claim no later than when you're answering a divorce complaint. However, I should also mention, as far as the timing, that you don't have to wait until divorce to file a claim for equitable distribution and getting into the dividing of the property of the marital estate. This can happen as early as separation, and oftentimes does. So that's sort of the timing, the time frame there is being on separate as of the separation date. As a claim for equitable distribution can be asserted, and right up until the time you want to certainly file before a divorce judgment is entered, or else you're forever barred from sort of claim. But that is the time frame that you're looking at here.
It's a great point. Absolutely. Well, I think on that note, we can move to our next of the big five, if we will be so kind as to call them that during this presentation, which is spousal support. So this is also a fairly, I would say, often used claim. So just as child support is designated to have a monthly amount to support the child, spousal support is designed to say that when parties separate or divorce, one party is not going to be left bereft or in poverty just by virtue of being divorced and losing access to the standard of living that they had while they were a couple. So there are two types of spousal support in North Carolina. There is the temporary spousal support, as we'll call it, which is post-separation support. It's aptly named because it is intended to provide support from the date of separation until the date the judge decides whether or not you are entitled to alimony. So that is more of a temporary relief. Alimony is the longer term spousal support. A lot of times it'll be for a period of months or years or decades, even depending on how long the marriage is. Very, very, very rarely will we see a permanent alimony award. I've seen two in my career. It's possible, but doesn't happen very often. Um, so really what we look at in terms of alimony, when I talk to clients about it, my biggest descriptor is that it's a gray claim. And what I mean by gray is that it depends in almost every aspect of the claim. It depends on how long you were married, what happened during the marriage, what you worked, where you worked, how much you earned during the marriage, where you work, how much you earn now, what your needs were then, what your needs are now. Um, pick a factor, it's considered. So just like equitable distribution, there is a list of factors that the court can consider when it comes to awarding spousal support. Um, Unlike child support, there is no magic calculator that we can plug in, and it is based on net income, not gross. So it is a different beast than child support. But typically, what we end up doing, and I'll get to this after I kind of do the definitions, is we end up looking at both parties' incomes and both parties' expenses to get an idea of deficits, surpluses, all those types of things. But before we get there, um, if someone is interested in asserting a claim for spousal support, they have to be able to prove two things. The first is that they are a dependent spouse. So what that means is that they are either substantially dependent on their soon to be ex for monetary assistance to meet their needs, or they are just actually dependent. They don't have enough to meet their needs, regardless of who's providing. So if they can show that, that is one half of the equation that could get you spousal support. Frequently, what we will see is dependency is shown by if you take your net income and you subtract out all of your reasonable monthly needs and expenses, and there's a deficit at the end of every month, that's a good indicator that someone is likely dependent. Um, but even if you're dependent, as much as you can be, you still are not going to be entitled to spousal support unless you can show that the other party has the ability to support you. So can't have one without the other. You can have a supporting spouse and no dependent spouse. Sorry, Charlie, no spousal support, and vice versa. But effectively, what you have to be able to show is that the other person, when you look at their net income, their monthly expenses, that they have the ability to contribute to help you defray your monthly needs and expenses. So when I say that things get a little gray, it comes into sharp distinction when we talk about the financial affidavit, which is what's next on this slide. So you heard Matt mention the financial affidavit when it came to child support. This is a required form in almost every county in North Carolina, but absolutely in Mecklenburg County. And effectively, what it does is it has you list out every source of gross income, all of your above the line deductions, so everything that comes out of your pay stub, your federal taxes, state taxes, all that jazz to figure out what your net income per month is. And then it has about 2 full pages of line items of potential expenses you could have every month, that the court could consider. That could be anything from your housing payment to your gasoline expenses to your groceries to your charitable contributions to vacations to pets, you name it, it's on this financial affidavit. So a lot of times where folks get into the weeds is what are their real expenses? What is a reasonable expense? Is it being accurately reported? And I will tell you that a lot of times when there's two parties who are disputing this, the dependent spouse's expenses are going to be naturally a little high, and the supporting spouse's expenses are also naturally going to be a little high, right? So it's a little bit more of an art than a science when it comes to predicting what the spousal support amount would be. You'll hear individuals toss around the idea of a percentage of net monthly income. There is no statute that requires a percentage to be applied. Some lawyers and some individuals will use that as a guiding principle. Others will use the principle of, does the supporting spouse have a surplus every month? If so, can that surplus be applied to the dependent spouse's deficit? So lots of ways to calculate this. And it is very, very, very different for every person as to what expenses they include, where they come from, what they're based on, and everything like that. There again is no hard and fast rule about how long alimony is supposed to be. I will say in Matt and I's arenas, most folks start with the assumption that it's going to last about half the length of the marriage. So if you're married 10 years, maybe we'll start the negotiations around 5 years. Married 30, 15, married for 1 year, 6 months. Obviously, these can go up and down, and anywhere in between, and the judge has discretion to set the duration as well as the amount if you're in the courtroom in front of them. Another very important thing that we just talked about on the last slide, but comes into sharp clarity here, is marital misconduct. So unlike any of the other claims that we've talked about today, this is the most common claim to hear folks talk about affairs being had during the marriage. And an affair by the dependent spouse will bar you from alimony. Really important to know, because the last thing that you want to do is file a claim for spousal support. It comes out at the trial that you had an affair, the judge is not going to award you anything. It is absolutely also considered if the supporting spouse had an affair. There are arguments as to whether or not it mandates alimony, but again, it depends a lot on the ability to pay, and things like that. But we won't get too into the weeds on that. When it comes to taxation, if you would have asked us more than 5 years ago if it was taxed, the answer would have been yes. It was taxable and deductible for the payor and the payee, but the tax laws have been revised, so it is now no longer taxable income, nor is it deductible from your taxes. So it's a net wash on that front. When it comes to health insurance, it is very common as a part of spousal support to ask for the supporting spouse to cover the dependent spouse on his or her health insurance through the divorce. The judge doesn't have to do it. Most often that I see, they will, especially if you reach an agreement. A lot of times it's expected to do that. But to the best of my knowledge and in my practice, after divorce, the spouse cannot be covered. So usually it does not go farther than that. When it comes to termination and modification, this depends a lot on the vehicle in which alimony is decided. So we'll talk a little bit about this on the next slide, I believe, in terms of what resolution avenues do you have. But if alimony is in a court order, it is typically modifiable. And what that means is, like the phrase you've heard us say before, it's a substantial change in circumstances. So most often in alimony, if it's been going on for a while and the payor has reached retirement age, a lot of times they'll file a motion to modify or a motion to terminate to say, hey, I'm about to retire. I no longer have the ability to earn the income I was earning. I can no longer pay this at the rate I'm paying, if at all. So it can be modified. If alimony or post-separation support is resolved in a contract, folks are allowed to put a non-modifiability provision in there to say, this is it, period, point blank. Neither of us will seek this to be modified through the courts at a later date. Termination is interesting. So there are a list of factors that will, quote unquote, automatically terminate alimony. The first is the death of either party. Alimony is not really a claim that gets paid through the estate, so typically the death of the payor or the payee will terminate it. The dependent spouse's remarriage will terminate alimony. In a very interesting statutory revision, the cohabitation of the dependent spouse can also terminate alimony. So what that means is, effectively, if the dependent spouse moves in with a partner, a roommate, or whoever who is effectively filling the role financially that a spouse would have filled, the court has the ability to terminate alimony. I won't necessarily get into a huge talk about cohabitation today, because again, that's a very somewhat niche area of the law, and there's lots of factors that go into it, but it is important to know that it is not just remarriage that will end alimony, it can also be cohabitation. A lot of times the most common termination method is simply that the time frame that was ordered has ended. So if you were ordered to pay for 5 years and the 5 years is up, that's it. So I think those are kind of the biggest bullet points. Again, spousal support is similar to equitable distribution in that if it's not asserted by the time you're going to get divorced, you're waiving your right to bring that claim at a later date. So I think those are my biggest points. Matt, any comments, corrections, other factoids you'd like to provide?
I think you covered everything very well. You just sort of reminded me that alimony is not taxed. It's not tax deductible for the payor. It's not taxed upon receipt to the payee. Similarly, child support is treated the exact same way. I should have mentioned that, but receipt of child support is not taxable, and it's not tax deductible for the payor of child support. But that's all I've got.
Absolutely. So I think, one thing that I'll mention before we get into kind of the last couple of slides, one of the important things to know for any of these financial claims, if you're filing a lawsuit in Mecklenburg County, there are several financial forms that are expected to be filed. You can learn all about them if you read the local rules. They're available online. But it is crucial for claims like equitable distribution and spousal support that these documents are filed at a certain time, because otherwise the judge will have the ability to not consider your claim, and a lot of times you will be very, very much hindered if those documents aren't filed or they aren't filed on time. You can be dinged for that. So I think it's important to give those a gander if you're going to bring any of these claims, just because they can be very important to the end of what the judge decides to do. Any questions about spousal support? Nope. All right. Um, so Matt, do you want to talk to them about the various paths to take and terms to know?
Absolutely. So a lot of what we've been talking about is, you get to court and what would a court order, if you're looking at child support or alimony or equitable distribution. But fortunately, there are other paths to resolution other than ending up in court before a judge. There are more collaborative approaches, where and this often happens where instead of going to court and fighting over and litigating claims, the parties will reach an agreement on how to divide up their marital estate, and how much spousal support one will pay to the other. And in those cases, you can have a separation agreement that will divide up the parties' property, any spousal support, and that's really the much more cost-effective, amicable approach to take. Whereas if you're going to court, you've got to pay lawyers and to go to trial, and it's just much. And that can also be a process that takes years. So oftentimes people will take a more a collaborative approach, of agreeing to everything in a private contract between them. I mean, I will say that child support and child custody, it can be part of an agreement, but that would be an agreement that is filed with the court as part of a court order, as opposed to equitable distribution, spousal support that can truly be part of a private contract between the parties. And so that's sort of the more collaborative approach there. And you can bring in experts to help value what the estate is, or even what one party makes as far as their income if they've got sort of a non-traditional source of income. And then sort of an in-between, that's the real collaborative approach where people, work things out sort of outside of court. And then, you've got that on one end of the spectrum, and then you've got litigation in court on the other end of the spectrum. And then in between, you've got mediation where, maybe you're in the court process, but through what's called a mediation, where the parties get together out of court, and you've got a mediator who kind of tries to help the parties reach an agreement. That's sort of usually a middle step in between a purely collaborative process and court, is to have the mediation be part of a process to see if you can reach that resolution without actually going to a trial, and litigation. And then you see arbitration mentioned there too, which is sort of very similar to court, except instead of a judge, you've got an arbitrator making the decisions, and instead of in an open public forum as court is, You've got a sort of a more private form being the arbitration. And that's typically something that the parties will agree between themselves to arbitrate the case instead of litigating in court. And that's sort of an overview on how I think about, the two ends of the spectrum, collaborative on one end, litigation on the other end. And then I should also mention that, mediation comes up usually while the parties have started litigation, but they're not quite to the point of a trial in the case. And so the hope is that with the mediation there, a sort of a middle step, maybe the parties can reach a resolution and agreement that is a little more amicable and a lot less costly than it would be to go and fight it out in court. And so mediation is a chance to resolve the case and any pending claims without actually having to go to a trial. Anything you'd like to add, Alexa?
I could find my unmute button. I think you covered it beautifully. One thing I will say that I think uh you've obviously mentioned, Matt, but I think can sometimes be a little bit of a common misconception for folks is if a lawsuit is filed, it does not mean that the parties cannot settle it. You can settle it the day after you file, you can settle it the day of the hearing. A lawsuit does not necessarily mean you are trapped on that path forever and you have to appear in front of a judge. So to the extent any of these approaches are used, almost at any point in time, the parties can decide to reach an agreement. In fact, that is always the court's preferred resolution of a case. They would love for every case to settle and no cases to go to trial. But unfortunately, that doesn't happen in every case. But you can absolutely settle, go to mediation, do collaborative, even after a lawsuit is filed, depending on your circumstances. All right. So, divorce. This is, it's fun because in my consults, we get to spend all of our time talking about these other claims that we've talked about. And divorce is actually of all of them the simplest, and the easiest. So, North Carolina is a no-fault divorce state. So what that means is it doesn't matter why the marriage is ending. Pick a reason. It could be anything. It could be nothing. But effectively, all you have to do to get divorced in North Carolina is live separate and apart for 1 year and 1 day. And what I mean by live separate and apart is North Carolina case law has defined that it is 2 roofs. So it doesn't matter if you're sleeping in separate bedrooms. Unfortunately, that's not going to be sufficient. It truly means 2 separate roofs. So as soon as one party moves out, that'll start the clock. So, if today, the 18th is the day that a spouse moves out, then next year on December 19th, 2024, they can file for divorce. And it's important to know that that 1 year and 1 day has to be done in a single stitch. If the parties reconcile in the middle of that period, or they resume marital relations during that period, it can restart the clock, and the year and a day will have to be done in one stretch again. So I think that's important to know. Something Matt mentioned earlier, but I think is prudent to bring back up is that, during this year and a day, you don't have to sit and twiddle your thumbs. That is actually when most folks try to resolve these other 4 claims. So child custody, child support, equitable distribution, and alimony. All of that can be resolved as soon as the separation begins. The only thing we have to wait for really is divorce. Again, we've mentioned it a couple of times. If equitable distribution and spousal support are not resolved or at least pending, and what we mean by pending is if you file a complaint for divorce and you also include claims for equitable distribution and alimony, they'll be considered pending. Those claims will be waived. They will be waived, and you will not be able to seek the court's assistance to resolve those going forward. So I think that's hugely important. Otherwise, there are a handful of benefits to being divorced. The first of which is that you can get remarried if you would like to. You can resume your maiden name. You can no longer be covered on the other party's health insurance. You can file your tax returns as a single individual. There's several impacts that it makes, but again, I think what we've talked about today is that the real substance of getting divorced really lies in these other claims. Effectively, the divorce itself, which we call the absolute divorce, is effectively just paperwork. And in almost every 90% of cases, there will be no hearing, there will be no live testimony. It's just the filing of the complaint. If you need to wait for an answer is filed. In a lot of cases, there's what we call a motion for summary judgment filed, which basically says, hey, judge, these are the facts. No one disputes them. We were married on this day. We separated on this day. We have this many kids. We're eligible to be divorced. And if the judge finds that those are the facts and they're not disputed, then in most cases, the divorce will be granted. So with that in mind, there's a lot of times where, everything gets resolved before the divorce, and the divorce is the last thing happening. In some cases, it's really complicated, and you can get divorced in the middle of it. You can get divorced near the beginning of it. There are some folks who don't seek to get divorced within that year and a day. I've seen folks who stay separated for 15 years without getting divorced. So it's really uh, dealer's choice. It just has to be at least 1 year and 1 day. Um, I think the only other important thing to talk about in terms of divorce is separation. Another question that I get fairly often is that there is no paperwork required to be considered separated in North Carolina. It truly just means one person moves out. There are claims such as divorce from bed and board. You'll hear people talk about doing a legal separation. Really, in for all intents and purposes, one person moving out, you're separated. So I think that's important to know because it does not have to be as complicated as some people think that it has to be. And if you are the party who's moving out, that will start the divorce. The only other thing I will mention, and it doesn't come up very often, but sometimes it does. In addition to the physical separation, there has to be, on behalf of at least one party, an intent to live permanently separate and apart. It does not have to be voiced, it does not have to be shared by both parties, but it has to be shown that at least one party had the intent to live permanently separate and apart when they do separate. So, with that in mind, those issues don't come up very often. Occasionally they do. Occasionally we'll see folks who dispute the actual date of separation. Um, that can lead to some complications when it comes to equitable distribution because the values of certain things are dependent on what that date of separation was. But in terms of divorce, really, truly, it is in almost every case the easiest part of the process. Uh, and I think the only other thing I would say is you are allowed to, in your application for divorce, if you are seeking to have your maiden name resumed, you can ask for it in the complaint. If you don't do that, once the judgment of divorce is entered, you can subsequently seek to resume your maiden name. A lot of people do it in that pleading. Some people do it after the fact. Dealer's choice. So, Matt, anything you want to add about divorce?
No, I think you said it beautifully.
Any questions about divorce? I know it's a little bit simple, but it can be tricky sometimes. Any questions? Nope. Okay. Well, I think we're down to our second to last slide. Um, and this one, I think Matt and I can both agree, as folks who traipse the Mecklenburg County Courthouse and the family law system, there are several pitfalls that can really hurt per se parties who don't know the rules to look out for, don't know the deadlines, the forms to file. Luckily in Mecklenburg, we have an excellent self-serve center that can provide advice on certain things. But if you have any questions about what it looks like for you or your partner to engage in any of these claims, I think Matt and I can both safely say we do recommend consulting a lawyer, as they will be able to give you more advice about your specific situation. Any other advice about getting a lawyer, Matt?
I do see that we've got the link to the Mecklenburg Self-Serve Center in the webinar chat there. So the self-serve center that you mentioned, can be a great, assistance program for in situations involving custody in particular, where cost can be an issue.
Absolutely. And I will say, in Mecklenburg, we are lucky we have a number of great judges, but every judge does something differently. And every case can result in a different result. So, obviously, you're not required to have a lawyer to file any of these claims, but it can be helpful when it comes to figuring out what's in your best interest to protect your interest, to protect your children's interest, all those types of things.
Yeah, every judge is different. Every county is different too in North Carolina. So
Every county is very different, and the rules in one county do not apply always in other counties. So I think that's really important. Look, we're down to the end. My contact info is not here, but I'm happy to provide it if anyone would like it. I added it to the front page, but neglected the back page. But I know from our attendees, you've asked some great questions. Any other things, you, Matt, from Shelby, that we can address while we still have time in this presentation?
Well, if anybody has any questions, certainly feel free to reach out to Alexa or me. You can see my contact information there. Happy to answer any questions that anybody has. I think there actually is one more question here. Oh, okay. Thank you.
From Shanine Patel. No questions here. Thanks for a great presentation. Thank you, Shanine. Very
Thank you.
kind. Very kind. All right. Shelby, anything that you want us to add?
No, I would just say that for folks that ever need it, the Mecklenburg County Bar, we offer a list of public resources that include some of the links that we've provided today. Those are available 24/7 if you go to mecbar.org/public resources. We also provide our lawyer referral service. And if you're looking for legal representation in South Carolina or in any other county in North Carolina, we also provide links to some other lawyer referral services in both states. So there's a lot of help available out there for folks that need it. And the Mecklenburg County Bar is a great resource to help at least get you pointed in the right direction at minimum. And again, as Matt and Alexa mentioned, the Mecklenburg County Courts, we're very lucky to have the Self-Serve Center. They do offer monthly clinics on divorce, custody, and child support for those that need it. So that's a fantastic resource. And I don't know what other resources are available in other counties, but I know we're really blessed to have that.
Absolutely. Well, it's been a pleasure getting to talk about, Matt and I's day jobs. Obviously, we've tried to keep it a little bit 10,000 feet, but hopefully you've gotten a good overview of what the main claims are. And again, if you have any additional questions, you can reach out to me, reach out to Matt, reach out to the bar. There are lots of resources around the county and obviously across the state to help folks get some answers for their specific cases.
All right. Well, I'll say thank you very much to Alexa and Matt for generously providing their time for this free clinic. We hope the folks that are in attendance got a lot of really beneficial information out of that. We're hopefully going to be able to provide a recording of this for other folks that might not have been able to join us. So I want to especially thank you both for your time today.
Thanks for having us.
Thanks, Shelby.
Thank you.
Thank you.